Aloha, good morning everybody. My name is Rob Hack. My company is Insight Inter-Asia, but I am a volunteer with the Hawaii Pacific Export Council, as we all are volunteers. The Hawaii Pacific Export Council, as you know, is a local 501c3 nonprofit based here at the Foreign Trade Zone, and it is our mission to help companies from Hawaii and the Pacific Islands export. Export does not mean California and Oregon and Florida, but it means Japan, Korea, Europe, Brazil, and foreign countries. So we have tremendous resources here in Hawaii to help our companies, and HPEC is one of those very valuable resources. And I welcome you to our seminar this morning on contracts for exporters. This is going to be a fairly deep dive into contracts, and we have two very esteemed guests who will be speaking this morning. I'll go through their introductions very, very quickly, but before I do that, I want to remind everybody our standard disclaimer that this is a public forum. We have essentially three audiences here: the live audience, we have an online webinar audience, mostly comprised of our friends and colleagues on the neighbor islands, and then we video these events and put them on the HPEC YouTube channel for later usage. So please understand that anything you say will be part of a public forum, and it's possible that your face could be on that public forum as well. So with that being said, I'd like to just very quickly, while I'm up here, go through the brief resumes of our two speakers who are going to be going through contracts, and then I'm going to jump back over there and pull up a couple of quick web pages and show you some things, and then we'll come back to the speakers. So Larry Foster practiced law in Hawaii and China for over 30 years. In China, he worked at one of China's largest international law firms. His experience includes civil litigation, real estate, and business law. In addition, he taught at UH Law School for 30 years, including serving as dean of the law school for 8 years. One of the courses he teaches at UH is small business contract drafting. He reads, writes, and speaks Chinese. Keith Suzuka is a partner with the Hawaii firm of McCorston, Miller, Mukai, and McKinnon, where he focuses his practice in real estate and business matters. Having spent roughly half of his professional career in Hawaii and half in Tokyo, approximately 15 years, primarily with the Tokyo-based law firm of Nagashima, Ohino, and Tsunematsu, Keith brings a unique set of skills, experience, and perspective in servicing the firm's Asian clients. So, as you can see, we have two very, very professional and experienced international lawyers here to go through contracts for exporting. And just before I bring them up to speak, I wanted to go briefly through a few websites for you, just for the record, so you know some resources that are available for you. We have here the website of the Hawaii Pacific Export Council, hawaiiexportsupport.com. I wanted to briefly bring up our archive on YouTube of the Hawaii Pacific Export Council's previous videos. As you know, many of you I see here in the audience and online are familiar faces, and so you will recognize, I know that guy right there. We see these seminars are very well reviewed, and so I suggest going back and looking through some of these topics. They're not all, of course, contracts. Here's e-commerce. We have one specifically on agricultural products. There's finance, there's marketing, what have you. A myriad of topics available here on that channel. And then I just wanted to point out that I host this show on Think Tech Network called Exporting from Hawaii, and we bring on very interesting guests. Perhaps the most interesting one is right here, Brenda, who's in the back. But this has been a really good venue to talk about exporting topics as well. So please look for that. And with that, I'd like to bring up Larry to talk about export contracts. Larry.
Okay, aloha. Keith and I have known each other for a long time, very long time. One of the things he may not know is that our two law firm I was at in China was related to the law firm that he was at in Tokyo. We always had one or two Chinese lawyers seconded to his law firm for a year or two. So we have deep, long connections back across many oceans. How many of you were here for the program the other day on intellectual property? I was. Okay. A couple of takeaways from that program that segue into this program. One takeaway is, well, we're not giving free legal advice. We came here for free food, but you're not going to get free legal advice. Everything that we say is not to be construed as legal advice. Keith is still an active practicing lawyer. I'm a temporarily, what's the word for it? Inactive lawyer. I'm not actively practicing law anymore right now. One of the takeaways, and I was talking to the two presenters on the intellectual property. One of the takeaways that is very important for them and for us is that this stuff is not simple. This stuff is not easy. The intellectual property things, it sounds simple enough. Oh, I just got to register my trademark. How complicated can that be? As the two speakers were saying the other day, it's quite complicated. And as they point out, frankly, they make more money cleaning up your mistakes if you do it yourself than if you come to them up front and have them register your trademark. And it's really the same thing for contracts. You're gonna have in your materials a couple of model contracts out of Europe for international transactions. They're good, decent contracts, but my strong advice is do not just copy those contracts and go forward. And you'll see a little more of the reason behind that as we talk. These are just models, just to give you an example of sort of what they look like. You can go ahead and do it. You're going to make a mistake, and then you're going to come to Keith or me and spend 5-10 times as much money cleaning up your mistake downstream. So pay the money up front and get some good professional advice before you go forward. The other takeaway I took from that, and I'm assuming you folks are all relatively sophisticated people. Some of you are younger, some of you are older. Those of us who are older know a message that I give to all my law students when I teach contracts or real property law or whatever. Trust no one. These people are not your friends. They're not your buddies. They're there to make money. So the intellectual property people were talking about, all these folks that once you start registering a trademark, it becomes public information, and all these people start sending you emails about what they can do for you and stuff like that. All those emails coming in should be deleted. Don't trust them. Same thing with dealing with contracts. The people you're negotiating with, yeah, they might be friends and stuff like that, but don't trust them. Be very careful. If they say a fact, verify the fact. So anyway, those are sort of two takeaways I had from that. April for HPEC this year is a great month because you got all lawyers this month. And you got to pay your taxes also. So this is a good month for everybody. So we're going to talk about export contracts. I teach a course on small business contract drafting, as Rob mentioned. That's about 30 hours worth of teaching, if you will. I also do a training program in China on small business contract drafting that's 7 hours. Well, I'm going to boil that down. Keith and I are going to sort of boil that down into 2 hours. So this is really sort of the tip of the iceberg of the kind of things you're going to want to know. So let's go to the first slide here. So what we're not going to cover today and what we will. So we're not going to teach you negotiation skills. Those are critical in business and also in contracts, because pretty much every sentence in a contract can be negotiated. Depends on your bargaining power. You're not going to be able to negotiate very well with Boeing, but maybe with a potential distributor or agent, there can be some negotiating. and pretty much literally every sentence can be negotiated, but very important. We're going to look at, I'll do a 30-second overview of the kinds of contracts you might run across in exporting. Why should you have a contract? The basic structure of a contract, they're similar all around the world. Issues with language and culture. So Keith will do Japan, and I'll do China. And then we're going to do what Rob had requested, a deep dive. I don't know if any of you have gotten to the bottom of the Marianas Trench. We're going to go at least as deep as the Marianas Trench in contract stuff in the last part of the program. In the materials you got, there's a copy of a distribution agreement, about 27 pages long. Time permitting, we'll go through most of that. And I think there's also maybe just the distribution agreement. The same organization also does an agency agreement, and you can look at that. So could I have the next slide coming up? I use a lot of humor when I teach. So here's contract drafting through or contract negotiations with Groucho Marx. Okay.
Don't look now, but there's one man too many in this room, and I think it's you. Now pay particular attention to this first clause because it's most important. It says the party of the first part should be known in this contract as the party of the first part. How do you like that? That's pretty neat, eh?
No, it's no good.
What's the matter with it?
I don't know. Let's hear it again.
It says the party of the first part should be known in this contract as the party of the first part.
That sounds a little better this time.
Well, it grows on you. Would you like to hear it once more?
Just the first part.
What do you mean, the party of the first part?
No, the first part of the party of the first part.
All right, it says the first part of the party of the first part should be known in this contract as the first part of the party of the first part should be known in this contract. Look, why should we quarrel about a thing like this? We'll take it right out, eh?
It's too long anyhow. Now what do we got left?
Well, I got about 1.5 feet. Now it says the party of the second part should be known in this contract as the party of the second part.
Well, I don't know about that.
Now what's the matter?
I don't like the second party either.
Well, you should have come to the first party. We didn't get home till around 4 in the morning. I was blind for 3 days.
Hey, look. Why can't the first part of the second party be the second part of the first party? Then you got something.
Well, look, rather than go through all that again, what do you say?
Fine.
Now I've got something here you're bound to like. You'd be crazy about it.
No, I don't like it.
You don't like what?
Whatever it is, I don't like it.
Well, don't let's break up an old friendship over a thing like that. Ready?
Okay. Now, the next part I don't think you're going to like.
Well, your word's good enough for me. Now then, is my word good enough for you?
I should say not.
Well, that takes out 2 more clauses. Now, the party of the 8th part...
No,
no?
that's no good, no.
The party of the 9th...
No, that's no good, too. Hey, how is it my contract is skinnier than yours?
Well, I don't know. You must have been out on the tail last night. But anyhow, we're all set now, aren't we?
Oh, sure.
Now, just you put your name right down there, and then the deal is legal.
I forgot to tell you, I can't write.
Well, that's all right. There's no ink in the pen anyhow. But listen, it's a contract, isn't it?
Oh, sure.
We've got a contract,
Sure.
no matter how small it is.
Hey, wait. What does this say here, this thing here?
Oh, that's the usual clause. That's in every contract. That just says, if any of the parties participating in this contract are shown not to be in their right mind, the entire agreement is automatically nullified.
Well, I don't know.
It's all right. That's in every contract. That's what they call a sanity clause.
You can't fool me. There ain't no sanity clause.
I can't think of a better arrangement.
All right, next slide. So a couple quick cartoons. The purpose of these cartoons is artificial intelligence is coming to the practice of law. This company, I don't know if any of you read this cartoon, but cartoons about they hired a computer to be their lawyer. The reality is that AI has reached law practice. Somebody did an experiment the other day, I think at a university. They took 8 what they call non-disclosure agreements, which are relatively simple kinds of agreements, and they took 10 lawyers and 1 computer, and they put them to the test. Who could review those non-disclosure agreements the fastest? The lawyers averaged about 2.5, 3 hours each person to review the eight non-disclosure agreements. The computer did it in 40 seconds. And the highest accuracy went to the computers rather than the lawyers. So at some point in time, I'd be a little nervous about it because I'm an old school guy, but at some point in time, the computers will be able to do this stuff for you. Next slide. And this is sort of the other thing, you gotta upgrade your software once you get into computers. Okay, purposes of a contract. Pretty simple. The idea is to write down, memorialize the agreement between the parties. Contracts identify and allocate the risk and rewards of a contract between the two parties. And that's the second major function of a contract. The economists say a good contract is efficient because one of the things it does is it identifies the risks up front and allows the parties to address what those risks might be, and who bears the risk of things. Is it which party bears the risk? So what if X happens? What about Y? These are the things that we look at. When you're looking for a lawyer, you want someone like Keith. What you want is someone who not only identifies issues but solves those issues for you. So you want the lawyer as a problem solver, but also to identify those issues. At the beginning of the contract, the parties are more willing to, or beginning of the relationship, parties are more willing to sort of talk things out and make agreement and make compromises. Once the contract is signed and if there's a dispute, then people lock down. So you really got to try and identify these things at the beginning. American lawyers love doing this kind of analysis and spotting these kinds of issues. This is one reason why contracts turn out to be longer and longer. So the distribution agreement that we have in the materials is only 27 pages long. And Keith and I were joking, yeah, that's the short version. Well, it's maybe not necessarily. But American contracts tend to be much longer because we really pay a lot more attention to these kinds of risks. So if you wait until the contract is signed and there's a dispute, then it's going to be much harder to address issues. Next slide. So the structure of a contract is pretty similar all around the world as you look at them. They'll have a title, introductory clause, what we call the recitals, the background facts, definitions, action sections. This is sort of the substance of the contract. Who's going to pay what to whom and how much. A very important section, representations and warranties. We'll talk about that in a minute. What we call the endgame provisions for termination of the contract or dispute resolution. What some people call boilerplate, but still very important information and things that are heavily negotiated. Indemnification, assignment, we'll talk a little bit about that. A signature page, pretty obvious, schedules and exhibits. That's the basic structure of a 3-page contract, a 200-page contract. This is the basic structure. Next slide, please. So the title, you want to be descriptive but simple. So you probably wouldn't want to just call it an agreement because there's all kinds of agreements. So if it's a distribution agreement, then call it distribution agreement. And one of the reasons you do that is it depends on the skill of the drafters, but you read some contracts and you're trying to figure out, well, is this a distribution agreement or is it an agency agreement? It might not be clear if it's not well written. Well, by putting it in the title, that is a good, strong clue what the parties intended. This is, in fact, a distribution agreement. Okay, next slide. Preamble. So that's the introductory paragraph. Identify the parties, the name of the contract, and the date. And it should also have the nature of the contract, so agency agreement, not simply agreement. Next slide, please. Some people like to put a lot of information in an introductory paragraph in the preamble. I don't know if you remember the Puerto Rico hurricane that devastated the power grid in Puerto Rico. And Puerto Rico put out for bid for some company to come in and restore their power grid. It's a complicated power grid because it's a very mountainous place and required special skill sets. It's not just flat land. So apparently the only company that put in a bid was a small 2-person operation out of a town in Montana you all know well, Whitefish, Montana. Just 2 guys working together. So they put in a bid. And this is the preamble of that thing. So as first party, this comes back to Groucho Marx. We try to get rid of all that stuff. Let me back up a little bit. A lot of contracts, the language you see in contracts date back to the 10th century England. And they have a lot of 10th century English style and language and stuff like that. And a lot of law firms, they love this old language. And senior partners love this kind of old language. In modern contemporary language, we try to get rid of this stuff. So part of the first part, we just get rid of that. But anyway, so the Puerto Rico Electric, I'll read it, give you a dramatic reading. Puerto Rico Electric Power Authority, PREPA, a public corporation and government instrumentality of the Commonwealth of Puerto Rico, created by, it goes on and on and on, as amended, represented in this act, meaning this contract, by its executive director, Ricardo, of legal age. He's married, he's an engineer, and he's a resident of this part of Puerto Rico. Too much information. We don't need to know if he's single or married, or we don't need to know who the names of his mistresses or anything like that. All that stuff should be left out. As second party, Whitefish Energy Holdings, LLC. Well, it turns out it's not an LLC. It's not a corporation. It's a partnership, but they somehow wind up describing it as an LLC. And they say LLC, a partnership. Well, partnerships are not LLCs. LLCs are not partnerships. So already there's a huge confusion in this sentence here. Organized and existing under the laws of the state of Montana, United States of America. By the way, Montana's in the United States of America. That's why we put it there, just to let you know that it's part of America. Puerto Rico, we all know is part of America, so we didn't need to put that in there. It just confuses the reader. Place of business, they give a address for the business, not really necessary here in the front. Herein represented by Andy. Andy's of legal age, he's married. Apparently he has no mistresses, there's no mention of them here. He's a resident of Montana. We don't know where in Montana. Montana's not a small state, but it's somehow, I figure he's from Montana and everybody knows everybody in Montana. It's just information that is really not necessary. And whose authority of representation is evidenced by corporate resolution. It's a partnership. You can't have a corporate resolution in a partnership. So the first words of this contract make you say, huh? What's going on here? Well, this is a small contract. It's only a $300 million contract. And arguably some lawyers looked at it. But my goodness, it was just a train wreck. And it gets worse during the rest of the contract. Rob, next slide. So background, the next section one is sort of, some contracts have a background section, some don't. The trend is to sort of not do it anymore, but it's a place to put information that's sort of not necessarily legally binding, but just give the reader of the contract some context of this. So if you're doing a M&A and you have 35 different agreements, then in the background section you sort of put this particular agreement in the context of all these other agreement. Back in the day in 10th century English and still today in Hawaii, lawyers like to use the whereas clauses, whereas, 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 whereas. Contemporary writing, legal contract drafting, we just get rid of that, that word. So in a distribution contract or whatever, we would say, you might say, whereas the company wishes to begin selling its products in Japan. Well, we get rid of whereas and just say, this is why we're entering into this contract. We want to start selling stuff in Japan. That gives some background. It's not legally binding, but it's just sort of background. So contemporary, we delete whereas, and sometimes we just delete the section entirely. Okay, next slide. Definition section, pretty obvious. If it's a short contract, words are sort of defined in the context, in the little clause in the section that they're doing. If it's a 300-page contract, then there's a separate section that deals with defining the terms used in the contract. Okay, next one. Action section. Yeah. Oh, here.
With respect to the definition section of a contract, in long contracts, they can go 20 pages of definitions. And I always tell my clients, don't blow past the definition section. That is a section, it might take you hours to get through. But once you get through, the rest of it sort of falls into place. But what you're defining as the property, what you're defining as damage, what you're defining as the term, all of these things are really the guts, and then these initially capitalized terms are interjected throughout the contract later. But a lot of people have a tendency to sort of just blow past the definition section thinking that's kind of boilerplate. Actually, that's where the uniqueness of a contract by a lawyer is kind of drafted.
A simple example would be the word trade secrets. Oh, we all know what trade secrets are. Yeah, maybe we do, but maybe we should define the term. So what a lot of Hawaii lawyers do is they turn to the Hawaii Revised Statutes, and in the Hawaii Revised Statutes, there's a legal definition of trade secrets, and they use that in the contract. But this particular, definition of trade secrets could be hotly negotiated among the parties, because some people want to put some things in, other parties might want to take things out of that. So again, highly negotiated. Next slide. The action sections. This is, if you will, the meat of the agreement. So agreements or mutual promises to perform the subject matter. The term, the duration of the agreement. This is a 6-year contract. It's a 5-year contract. The territory, particularly in an agency and distribution one, this is territory and duration are the two most important parts, if you will, of a distribution or agency agreement. How long is this going to last? What is the territory for your distributor or your agent? Again, hotly negotiated by the parties. Payments. How much is it going to be paid? Is it going to be paid in U.S. dollars? Is it going to be paid in yen? When is it going to be paid? How are they going to be paid? Is it going to be a check? Never accept a check, particularly a counter check or something like that, but maybe a wire transfer, these kinds of things. So very important to have that in there. So territory, payments, term, and the mutual promises. Okay, next slide. Representations and warranties. So when you're entering into a contract, each side sort of makes representations to the other side to encourage them to enter into the contract. So the Whitefish, Montana contract, these were literally the only guys in the United States that really knew how to do this kind of work. So arguably in the contract, you would expect a representation by them. We are highly skilled in restoring grids in mountainous regions. Curiously, that does not exist anywhere in the contract. They never made that representation in the contract. That was a mistake by the government of Puerto Rico. So what we would want to have here is, for example, distributor has 10 years of experience as a distributor of foreign food products in Japan. That's a pretty strong representation. This gives you some comfort. Oh, I'm dealing with someone with experience. If it might just be some guy who's he looks like Keith and looks very serious and experienced in something, I don't know what. But he's not going to make a representation that he's done this for 10 years because he hasn't. But you want that representation in your contract. You want them to assure you that you know what you're doing. Some people like to hide representations and warranties. So this is back to the Whitefish contract. This is page 30 of that contract, Article 68, and the title of this section is Penalties, Fines, and Disallowed Costs. Okay, so you think that's about penalties and fines and disallowed costs. Well, it's not. Buried in it is a representation. PREPA hereby represents and warrants that FEMA has reviewed and approved of this contract and confirmed that this contract is in a form acceptable to qualify for funding from FEMA. Guess what? That was a lie. FEMA never approved it. FEMA was furious when this contract was made public, and the contract said that FEMA approved the contract. They didn't. It was a lie. But where do you put a lie? You hide it. So you hide it in a section about penalties, fines, and disallowed costs. Anyway, next slide. Representations. What's a representation? It's a statement of fact that was due on the day that it was made, on the day that the contract is signed. And the intention is that the other party is going to rely on it. So you could sell a car. The car is in good working condition, or a distributor has 10 years. We saw that already. Next slide. There's also what we call warranties. So contracts have representations and warranties. So let's look at, a warranty is a little bit different. It's a promise that a statement is true. And here's a warranty. The car is in good working condition. That may remind you of a representation we just saw. Another warranty. Distributor has 10 years of experience as a distributor. Looks just exactly like the language of the representation. So sometimes the language is exactly identical. It gets a little complicated here because there's different remedies and things like that. The modern trend is to have representations, just have a section that says representations and warranties, and just list everything and let that get sorted out later as to which is a representation, which is a warranty. But you want these. On your side, you want to have them make all kinds of statements that you can rely on. You yourself, you want to make as few as possible because you don't want to get caught and stuff. Highly negotiated here. And this is a lot of the what-if stuff. This is what lawyers help you do, identify what kind of statements do you want your distributor to make to you? What kind of promises do you want them to make? Next slide. So they're often the same language. So again, this distributor represents and warrants as follows, and bam, bam, bam. Next slide, please. You should also have a section on how to terminate a contract. One of the contracts we use in this course that I co-teach with another friend on drafting small business contracts was two people, if you will. A fellow was at his favorite restaurant one day and found out that the owner wanted to sell the small restaurant, wanted to sell the restaurant. So they sat down and on a napkin wrote out the contract. And they saved a lot of money in lawyers' fees in drafting the contract. The problem is that the contract left out pretty much everything, including how to terminate the contract. And surprise, surprise, the deal didn't go well. And one side wanted to terminate and yada, yada, yada. So they spent a lot of money hiring Mark Sklov, that Keith knows, to sort of sort this stuff out. So you should have some sort of a provision in there how to terminate the contract. Sometimes contracts terminate automatically. 3-year contract. After 3 years, terminates. But what if there's a problem in year 1, year 2? How do you terminate it? You want to address that issue up front. Next slide, please. Okay, jumped ahead. All right. So common general provisions, so-called boilerplate. Oh, don't worry about that. That's just boilerplate. Hotly negotiated all the way through. And these are some examples. We'll go back and look at them in a little more detail in a minute. But an indemnification agreement, assignment or delegation, can you do it? Dispute resolution, what we call merger clause. We'll talk about these in just a second. So next slide, please. So indemnification provision. The company shall indemnify and defend the distributor against all losses and liabilities arising from third-party claims that the product infringes any ownership rights of third parties. So you're selling, you have a product here from Hawaii and you want to distribute it out. Do you have the intellectual property for that particular product? Does someone else have it? That's important information for your distributor to know. But we put in this indemnification thing in here that protects the distributor here. And so the first one goes to sort of intellectual property claims. The second one goes for product liability claims. It's not just America, but the whole world is pretty litigious. So if you sell a soap product in China and somebody gets sick from using that product, then there's a product liability claim. And who is responsible for that claim? Who in the end pays for it? The distributor or the manufacturer? Okay, next one. Dispute resolution, very complicated. So we're talking about export, and we're talking about export outside the United States, and primarily to countries that don't speak English. If you're going to England or Canada, yeah, there's some slight differences in legal phraseology and stuff like that, but basically the language is the same. But you start going across language and cultural barriers, this gets very complicated in a contract. So one of the questions is, and we'll talk a little bit more about this in a minute for Japan and China, but if it's a bilingual contract, which language prevails? Which language is the key language? The U.S. is in the midst of negotiating a trade deal with China. And the negotiations are all in English. The working document is all in English. And a lot of us who know China are thinking, what kind of document, what does the Chinese language version of that document say? And when the agreement is finally reached, is the Chinese language version going to be the dominant one, or the English language version going to be the dominant one? Or so it gets very complicated, and it's important to address these issues. So if you, in the termination part of it, do you terminate through a lawsuit, or if there's going to be some sort of a claim to use alternative dispute resolution? So you got sort of two choices. Do we settle it through what we call ADR, alternative dispute resolution, or do we bring in the litigators and sue? A big decision, a huge decision to make, and again, hotly negotiated as to how to do it. Where is this lawsuit going to take place? Is it going to take place in Honolulu, San Francisco, Tokyo, Shanghai? What law governs? Is it going to be Hawaii or U.S. law? Is it going to be Japanese law? Is it going to be Chinese law? All these things hotly negotiated in a contract, and hotly negotiated also again depends on bargaining power, right? So if you're a distributor, if you're a supplier or company here in Hawaii, and a company in China called Alibaba wants to be your distributor, they're a huge mega company. You're going to have very little bargaining power with them. They're just going to give you a document and say sign it. You might want to read it first, but it all depends on bargaining power. Okay, next slide. Assignment and delegation. So the company is going to be selling this product to the distributor, and the company eventually decides, hey, we want to get out of this product line, so we're going to assign our duty to produce this product to another company. Can you do that? Well, you got to address that in the contract. So here's one. The company may assign this agreement and any of its obligations without the prior written consent of the distributor. Where do you think the bargaining power is here? The company, they have all the bargaining power. We can do whatever we want, and you can't, there's nothing you can do about it. However, the distributor may not assign it. So I have the power, but you don't. Oh, and by the way, my consent is at the sole and absolute discretion of me. You made your request by email. No, I didn't want email. I wanted a letter. I'm gonna deny it. You sent it on A4 paper. No, I didn't like A4 paper. I wanted standard U.S. size paper. Sole and absolute discretion. Very huge. Well, very dangerous for one side because there's just so many things that can happen. This actually came out of a actual distribution contract that I looked at once for a Chinese client, and he was going to be the distributor of a product from the U.S. Okay, next slide. Merger. So when you're going through negotiations or buying a car, whatever, I'll use a car buying example. Some years ago, decades ago, my wife and I bought a Volvo from Volvo of Hawaii that was out on Hawaii Kai. And they were a very nice, friendly group out there and good folks, and it was a good car and a good price. So we bought the car. Well, and we were thinking about buying the car, and the salesman said, oh, by the way, for the life of the car, you got a problem, you bring it in here and we'll give you our free loaner. So later on we had a little issue with the car, we take it in. Guess what? The salesman was no longer working there. He made an oral representation to us. It was not in writing. And Volvo of Hawaii, rightfully so, said, hey, it wasn't in the contract. There was a provision in the contract that says any kind of oral agreements or oral statements that were made are not part of this contract. So you be sure that everything that the other party said was going to happen is written into the contract. Pay close attention. I come back to trust no one. Okay, next slide. Signature, pretty simple, just signing of the parties. Next slide. Schedules and exhibits, pretty simple. Next slide. Okay, so that's the basic structure of a contract, right? And they're all going to be pretty much the same. If it's a contract that originated from a very old and prestigious U.S. law firm, it's going to have a lot of 10th century English in it, but then you just have to struggle your way through that. I'm sure Keith's firm got rid of 10th century English a while back. But anyway, so Keith is now going to talk about crossing borders, language issues, and culture issues with contracts. Okay.
Hi, my name is Keith Suzuka. Larry sent me this very complicated, and he worked very hard on trying to get me directions to how to come here. My office, turns out, I came a couple days just to make sure I wasn't going to be late. I got here in about a minute, and if I were a better golfer, I could hit a golf ball from my window to this building. I see it as I work every day. By the way, the suit is not for you guys. I'm sorry, I'm misdressed. I have a liquor commission hearing this afternoon. Okay, I lived in Japan a long time, 3 times, twice as a lawyer, maybe about 15 years. And I guess one thing I did want to stress that I am not a Japanese lawyer, a bengoshi. That means licensed to practice Japanese law. When I was working in Japan, I was licensed to practice Hawaii law and U.S. federal law in Japan. Okay, it's a long story, but in any event, so I'm not a Japanese lawyer. But I thought I would give you some general oversight, maybe just give you some idea of why Japanese may do things the way they do and kind of what to watch out for in a Japanese contract. I guess my first observation that I wanted to pass on to you is in the United States, most contract law is a state law issue. There's very little federal law that deals with this fundamental contract law rights of parties. But in Japan, there is no such thing as a state. So Japan is basically one big state. It's, you know, and so when you hire a Japanese lawyer, that lawyer is not licensed just for Tokyo or for Osaka or Hokkaido. That lawyer is licensed to practice Japanese law anywhere in the country. So that's the first thing that I kind of wanted to point out to you. So you don't fight about things like this law will be governed by the laws of Tokyo or Osaka. It's going to be just Japanese law, and then you have the discussion about whether it's governing law is going to be Tokyo, Japan or Hawaii. By the way, I just want to make sure I'm not overdoing my time. So that's the first thing I wanted to mention to you. The second thing is that doing deals in Japan takes a long time. If I used to tell clients, if you anticipate a deal being done in a month in America, then you're probably going to be done in about 3 months in Japan. There's a number of factors for that. One is that you need everything translated, and you've got that impediment to speed. But the other thing is that Japan, they have their decision-making process is very different. So I guess if you look at the typical American, and these are really broad stroke comments where you can point to many, many exceptions. But if you look at the typical American negotiator, they approach the table thinking that with the facts and logic and brains that they can cut a deal. And there's writings that sort of characterize the American negotiator, sort of like John Wayne, a cowboy kind of guy, walks in, thinks he can negotiate everything. Everybody will understand the logic of his right, and they'll all agree with me at the end of the day. In Japan, no matter how right you may be, in Japan, there's a decision-making system. And it's driven by many things, but I guess one of the things is that there's the ringi system, which I'm sure probably all of you heard, where every department that's involved in a decision process sort of has to put their hanko on that. So it goes to accounting, it goes to engineering, it goes to somu, general affairs, it goes to whatever departments are going to be impacted by it. Everybody's going to sign off on it. When everybody signs off on it, everybody's taking responsibility and buying into it. And so it's going to take time. And the consequence of that is, in America, we have this tendency that until the contract is signed, we can always renegotiate. Okay, in Japan, if you think about their system, it's very, very adverse to changing course midstream. Why? Because, first of all, you have a system where, again, a lot of changes recently and stuff, but the typical Japanese mentality is, I joined this company for life. When you're young, you're out of college, everybody starts April 1st, you join the company and you're going to move around and you're going to move up in this company. And very little lateral movement. So if you screw up, it's hard for you to go find another job, particularly in that industry, because you're kind of known as the guy that, wow, he left his company. Okay, so there's this strong bond between the employee and his company. In America, we move around all the time. So, we cut deal. I had to go back and tell my boss, you know what, they changed the deal, or I wanted to change the deal. Nobody really cares. I'll go find somebody else to work for. In Japan, you can't do that. Remember, all his bosses went and put their seal on this document, okay? And they're all headed towards one direction. And then the American company comes in and says, oh, you know what, something happened. We have to change the deal. You're putting that guy the guy in charge who has to report to all these guys who put their seals on a document in a really tough position, it's going to be extremely hard for you to get a company, once they're started to commit, to buy in. The benefit of that system is Americans change the deal all the time. So, I represented Lehman Brothers before they went bankrupt in negotiating with Mori Buildings on this big office complex called the Mori Towers or something like that in Tokyo. And they changed team leader for the negotiations 3 times. And each time we changed the deal, the Mori people were going crazy. And you can't switch the deal on the Japanese the way you can with another American. Things changed, please understand, so Japanese will not move. They move slowly, but once they commit, they're committed because everybody in that organization bought off on it. Americans are much more easy to change, but keep that in mind when you're negotiating with Japanese. Of course, there's small, young entrepreneurs that come to Hawaii, and one guy makes all the decisions, and yeah, there are guys like that. But if you're dealing with an organization, then keep in mind the guy that you're putting in a really tough position, because he ain't going to be moving jobs, and he's got a lot of people that he's been getting to work with him throughout this process. Let's see. Just a general rule about contracts. Contracts over the period of time that I was in Japan, I worked as a lawyer there for about 15 years, have become tremendously more globalized. They're much longer. They look very much like the kinds of contracts that Larry was talking about. But, fundamentally, Japan, that's a very new phenomena for Japan. And so I worked at a very international law firm, so we dealt with people from Europe and Saudi Arabia and everywhere. So the contracts all look like that. But if you were to be dealing with a small person from Nagoya, you might actually find that they're not used to the long international global type of contract. But contracts are binding. You can pick your law, Japan or Hawaii law, and that will, as a general rule, subject to some conditions, be enforceable. Japanese contracts, one trick or problem that Americans trap that they fall into is that it's a small contract, 5 pages sometimes. So they read all the words and they say, okay, yeah, that's no problem. They don't get a Japanese lawyer to look at it. Be careful, because Japan, just like the United States, but more so, in America, we've developed this system where American lawyers are paid to think of every eventuality, every problem that could come up, and we put it in the document. Japanese will give you a very short contract, and if it doesn't say something, then the law fills in that provision for you. And so if you don't know what that law is, but they know what that law is, then you're at a disadvantage. Okay, so a very short contract doesn't mean that those are the only terms that you're working with. That means that you've got to take a look at the law because the contract doesn't say anything about it. Okay, I'll give you one example. Larry had that merger provision up. Okay, and the merger provision says something like, this agreement constitutes the full and entire agreement of the parties, and you can't bring in, I guess it was your story about Volvo. Okay, in America, you put a provision in like that, and it is generally enforceable. Okay, fraud, you got some other issues, but generally that's an enforceable contract. In Japan, if you don't put that provision in, and even if you do sometime, but if you don't put that provision in, any type of stuff can come in. Or he told me this, that's why I signed. All that stuff is admissible in court. So by not saying something, you're basically saying, okay, I agree that whatever Japanese law says, that's what I'm going to live with. Okay, and if you don't know what Japanese law says, you've got an issue. So don't be tricked by the short contract. There are many, Japanese law generally in the contract arena, I'd say, wild guess, 80% of what you think is going to be the same as in the United States. 20% is different. Okay, are you an optimist or a pessimist? The optimist would say 80%, I got it. I can live with that risk. The pessimist would say 20%, I don't know what's different. I'm nervous about this. It kind of depends on how you look at things, but it's generally the same, but there are a bunch of differences in the law. Let me end with one more topic that I like to talk about. As a general rule, Western contracts, there's always a balance in contract drafting, okay? And it reflects contract, just like law reflects culture and the cultural difference between countries. And so in the context of American or Western versus Japanese contract philosophy, Americans like to have certainty. They want a contract that tells you what your rights are going to be throughout all eternity and throughout all these different things that may happen. Japanese like justice. Okay, they approach a contract by basically thinking, well, you can't really put everything that's going to happen from now to eternity into a contract. So the courts will adjust if there's something turns out to be out of whack, not reflecting justice, not reflecting fairness. So that's their fundamental starting point compared to a U.S. Western contract, which is, I want to know exactly what my rights are forever. It started to change, especially, I went to Japan during the Ryudoka, which is like real estate securitization. And so you had all these leases that were going to be securitized, put into REITs. And these REITs needed to know how much rent revenue are going to come off of these leases over the term of the REIT. But Japan lease contract said, well, if circumstances change, the tenant can reduce the rent. Okay, that made trying to securitize, package up leases, and to sell them as REIT shares extremely difficult. So Japan started to pass laws that kind of said, well, okay, when you say your rent is $1 per tsubo for 5 years, it's going to stay that. It's not going to move around on you. Okay, so fundamentally, Japan is looking for fairness, and Westerns are looking for certainty. Okay, that if you take that, so here's the example: distribution agreements. Okay, the typical atypical form of a distribution agreement is that we sign this. The term is for 1 year, and if at the end of the term, it will renew automatically unless one of the parties says that we don't want to continue this agreement anymore. It's kind of this continuing agreement. Those agreements are actually not going to necessarily be respected by a Japanese court. So just because you think you can cancel this agreement with 30 days notice at the end of the term, the Japanese courts don't necessarily follow that. There are a couple of major cases in Japan. The ones that are cited are both cosmetic companies, Kao and Shiseido, and they entered into distribution agreements with housewives that wanted to go out and sell their products to their friends and things like that. And the courts in both of those cases basically analyzed whether you could terminate, and this also applies to renewal, whether you can fail to renew a contract at the end of the stated term by analyzing these types of provisions, okay? So they said basically you can terminate a distribution contract in accordance with its terms if you provide reasonable notice. And how do you decide reasonable notice? The court will look at these factors: ease or difficulty and time and cost needed for selling off inventory products. So if it's going to take you more than 30 days for the distributor to sell off its inventory, then it's not reasonable for you to follow the rules of the contract by saying you can terminate upon 30 days notice. Unamortized capital investment, including employment of additional workforce by the distributor in reliance on the continuation of the distributor relationship. Goodwill, sales, and profits of the distributor generated from the distributor agreement. You know, what the Japanese court is looking at is, well, you know, you came in, you gave the distributor the right, the distributor worked really hard, built up the goodwill and name of your company, and now you want to take it away after 1 year? That doesn't sound fair to us. So even though the distribution agreement says, yeah, you can terminate at the end of 1 year, court's going to look at it, you know, how much time and energy and how much goodwill was developed by the distributor, and is it fair now that the company can just take it away? Relative weight of the distributor business in question to the entire business of distributor. Is it 100%? How's the distributor going to be economically if the contract was just terminated? Ease or difficulty and time and cost of shifting the resources employed in the distributor business in question to some other business. To what extent the reliance on the continuation of the distributor relationship was induced by the supplier. Amount of time that would be required for the distributor to find a new supplier. Relative size of the distributor versus the supplier. So all of these things will come into play. And so the warning here, last point, just to reemphasize, is you look at a contract and you think, okay, it says 1 year, I can terminate if I want. Know the law, know Japanese law, understand that courts in Japan approach contracts differently. They're looking more towards fairness, while Americans are looking more towards, well, that's the deal you signed. Everybody agreed. There's certainty in that, and so we're going to allow you to live by that live or die by that contract. Now, of course, America is also the same. We have tendencies to try to find fairness and equity and all this other stuff, but you got to understand the relative weight that Americans put on certainty versus the relative weight that Japan puts on fairness and equity and those types of things. So those are just sort of some cultural types of tips that I had in that I thought maybe you could approach doing things in Japan a little bit more aware. Thank you.
Thank you, Keith.
That's great. Thank you.
Okay, let me speak briefly about China. Speak briefly about China, and then we'll do some Q&A, and then those of you that are still awake will go into the distribution contract, a deep dive. I want to highlight something Keith mentioned about the courts in Japan using fairness and sort of a bigger principle of justice. Exactly the same thing happens in China. A U.S. company thinks it has a watertight contract and they have a clear win in the Chinese court. Well, the Chinese court's going to do what the Japanese court does. It says, yeah, okay, that's a nice legalistic argument, but is that fair to everybody? So they're very much willing to look at sort of fundamental fairness to all the parties. So as in China, same as Japan, the negotiations take a lot longer time, maybe about the same as in Japan, maybe sometimes longer. In China, the Chinese party often wants to sort of get to know you. It's a personal relationship. So you got to sort of establish that personal relationship. So there's a lot of parties, and back in the day, a lot of drinking. Less drinking in China, a little less drinking in Japan these days, but it's still a part of it. And by drinking, I don't mean tea. I mean sake or Maotai. And sometimes the Chinese party will say, hey, we're friends. Friends don't need contracts. Trust no one. Get a contract, all right? Go forward. Some people say that in China, this is it's a true adage that, well, in China, the contract is just the beginning of the negotiation. And that's true. It frustrates the heck out of Westerners coming to China. They sign this beautiful long contract and everything, all the what ifs and what abouts were answered and stuff like that. And everybody signed, everybody was friends, they had a big banquet. The next day, 2 days later, a month later, the Chinese party comes back and says, by the way, that provision on page 4, we want to change that. I once represented a Chinese fellow, and I've used some of his distribution agreement language here. He very much wanted to be a distributor of this product from the U.S. Very much wanted to be. So he accepted basically what was an unfair contract towards him. He said, "No problem. We'll just renegotiate it later on. Let me sign it, and we'll go forward." And that's sort of the style. Okay, next slide. If you get the Chinese contract, you get them to agree that any disputes will be resolved in Hawaii at the circuit court, just down the road here, so that we can get a U.S. judgment against you. The Chinese party would say, "Sure, I'll sign that," because they know that U.S. judgment is not enforceable in China. No U.S. judgment is enforceable in China. Likewise, no Chinese judgment is enforceable in the U.S. Complicated stuff. You got to know that as you're entering into and the same thing for arbitration awards. A contract in China, it's not enforceable in China unless it's written in Chinese. They want to see the judges, surprisingly, well, actually a lot of Chinese judges speak some English, but they want a Chinese language version of the contract. And is that the next slide, Rob? That's the end. Okay, so let me tell you. So let me talk about language for just a minute. One of the most complicated. Anyway, I did a distribution agreement at the Chinese law firm that I was at in Shanghai. There was a Korean company that wanted to find a distributor in China for its Korean food products. Very popular in China. This was big business. So this particular fellow, he'd spent some time going out to Europe and finding distributors in Europe, and he had developed an English language version of his distribution contract. It was a mess. It was just a total mess. So he found a Chinese guy to be a distributor, and the Chinese guy did not speak Korean. The Chinese guy did not speak English. So a friend introduced him to our law firm. So we had a Chinese lawyer who spoke Korean. We had a Chinese lawyer who spoke English but also knew Chinese law. And we had this haole from Hawaii who spoke Chinese and English but was not authorized to practice Chinese law. It took us about a day, 3 different languages, coming out with three contracts in 3 different languages, trying to get to a point where all 3 contracts in that native language said roughly the same thing. I could not verify the Korean contract because I don't speak Korean, but I do know that the Chinese contract and the U.S. contract were about as close as one can get to doing that. But these languages are important. So even in Japan, a lot of people in Japan speak some English. But more likely, if you have a Japan distributor, they're going to send you a Japanese language contract and for you to sign. And my advice is don't sign it. Talk to somebody. Talk to somebody who knows Japanese law. Talk to someone who knows Japanese, and they can give you a better sense of what this contract will actually say. And some of the things that Keith was talking about, and myself too, that fairness sometimes is a bigger issue. So why don't we pause now for a Q&A, and then we'll deep dive into the distribution agreement. So are there any questions out there? I'm looking at the Honolulu audience. I'm not looking at the neighbor island audience, but the Honolulu audience. Anybody? Yes, sir.
I have an opportunity in Korea, and it's not quite what we're talking about here, but can both of you maybe make a quick comment on the same example of, exporting and contracts in Korea compared to China or compared to Japan?
Okay. So the question is, this is a person who's looking at doing some business in Korea, and are there the same issues in Korea as you might find in China and Japan? The same overall issues. The Korean people, they're, as with the Chinese and the Japanese, they're very, very sophisticated business people, but maybe they don't all speak English as well as you would like them to. I'll assume you don't speak any Korean. So you're going to have some cultural issues, and it's probably some very similar kinds of cultural issues, and certainly the language issues in the contract. You need to find a lawyer who speaks Korean, speaks and reads Korean and English, so that they can assist you on this side.
Do you happen to know if Korean law is civil or common law? Civil, right? Probably. Civil law.
So the world is divided into sort of by lawyers. We divide things, categorize things. There are 3 or 4 sort of legal systems around the world. There's something called Sharia law. There's canon law out of Rome, and there's civil law and common law. So the U.S., Canada, Australia, also the English-speaking parts of the world, we have a system that's called common law. The rest of the world, so we're a minority, the rest of the world, the majority of the world have something called civil law. And it's a different legal culture, and all the more reason to have someone that knows Korean law to help you understand that contract.
We at HPEC here, our programs tend to focus on Japan and then maybe secondarily China or Korea, because that's where most Hawaii companies are interested. But the things that they're talking about, you could easily substitute the EU or Finland or Brazil or something like that for wherever they say Japan. There's going to be some differences, and I think the goal is just to highlight what some of those differences are that you should look for. And your attorney should be doing the same thing.
Okay.
A question about the indemnification clause you had up earlier when looking at the consumer goods distribution agreement. Typically, domestically, we would list our distributor as additional insured on a certificate of insurance. But if our general liability policy doesn't extend to international markets, do you find that clause is still kind of required by most distributors?
I think, well, it's a bargaining power issue. Who's going to read? So the distributor is going to be, well, both sides want an indemnification provision. You want to be indemnified for any mess-ups that your distributor makes, and they want to be indemnified if there's any intellectual property issues or any product liability issues. So they're both going to want to have their indemnification provision. And it gets complicated when you have insurance coverage, and that probably becomes an insurance law issue more than a contract law issue. But yes, indemnification provisions are very important. The Chinese courts don't like indemnification provisions. They're not fair. So you have to be careful about that. And other countries may have similar thoughts about them. You see them in Chinese contracts, but again, the underlying rule is one of sort of fairness.
Contracts with China, different regions of China, north, south,
big cities, small towns, are there any major differences in negotiating in terms of a contract too? Because they're such a big country.
Okay, so the question is, China's a big country, and as you go about China, are there any differences in I'll sort of broaden it, sort of in regional differences in terms of law and style and stuff like that. Much like like Japan, China is a national legal system. So the law, in theory, is the same all across China. The reality of it is that it sometimes gets interpreted a little bit differently, and we have the same thing in the United States. I used to teach U.S. securities law. Under U.S. securities law, what is a crime in New York City is not a crime in Hawaii. Under federal law, go figure. But generally it's a federal system, so it's sort of the same. In terms of negotiating and styling that, I haven't negotiated across China, but I think you're going to find a lot of very similar stuff. My wife, one of my favorite images of my wife is sitting in a village in rural China, 6 hours by car away from the nearest thing you might even call a city. And they're talking, negotiating with the leader of the village, if you will. It's a circle of stools on a sort of hard ground, open area, no concrete. It's quite rural, and they're all sitting there smoking cigarettes. In China, you negotiate by smoking. My wife does not smoke, so she tried to get upwind of all the smoke. Two folks get in the fender bender in China. You know they reached an agreement because they all share a cigarette, and here you have a cigarette. But across the country, in China, cigarettes are all around the country. So that's a common negotiation tool. But I think you're going to find general similarities across. Having said that, there are parts of China that are extremely sophisticated. I shouldn't say this, well, it's a public audience, what the heck. Far more sophisticated than most of our businesses in Hawaii. And there are parts of China that are extremely unsophisticated. So you're going to have some very different kinds of experiences. I remember we were traveling in China, and this little village that we were passing through, and it was a area with minorities, and there were two Han Chinese guys. Han is the main ethnic group in China. Looked like very much slick city business people, nice suits and nice haircuts and stuff like that. And sitting between them was one of the local minority people, and this guy looked totally clueless. And they were clearly negotiating something with this guy. I was so tempted to come in and say, "Hey, I'm a lawyer, I'll represent you." But I didn't, in this part of China, I didn't really speak that dialect, and I'm a Trekkie, so I don't interfere in local affairs. Yes, in the back of the room.
Larry, could you mention, though, a little bit more on the sophistication of the legal systems throughout China and the ability to enforce agreements, say, in a major city such as Shanghai, Beijing, versus if you're further out in the countryside, and the development of the rule of law in the countryside, because there may be, in some instances, some disparity in being able to do that.
Okay, again, China's a big country. One legal system, but a big country, and various levels of sophistication. So if you talk to lawyers in the big cities, Beijing, Shanghai, Guangzhou, what have you, and their clients are not with them, they'll say, we get and even Chinese lawyers with Chinese companies, we get pretty good justice in China with the Chinese courts. Fairness is a big, huge issue you got to watch out for, but we get pretty good justice in China. The further you move away from that, the quality of the judges starts to fall off, and things get pretty rough and rugged. and we sometimes call it sort of the wild, wild west out there. Far more likely to have local political interference. So if you have a case against a company in a city called Chengdu, getting more and more sophisticated on Western China, but more likely the judge is not going to be all that sophisticated. There's going to be a lot more sort of local pressure on the judge. And did I tell you you're suing a local company? I used to practice law in Hawaii regularly, and I used to be involved in litigation. I remember going to Hilo once for a case to represent my Oahu client. And the local, very local Hilo lawyer kept reminding the judge and the jury, oh yeah, Mr. Foster's from Oahu. He's not from Hilo. So you see these things all around. It's common. But so the Chinese government is pushing people more and more, Westerners, to go out to the other parts of China and help bring in foreign direct investment. But the political risk factor increases exponentially as you, mile by mile, as you move away from the big cities.
I just wanted to go back to the question right before and add a Japan comment on it. Another thing for Hawaii people to look at, another prism for Hawaii people to look at Japan through is, if you think about it, Japan is a very homogeneous society. Everybody kind of starts off the same. And again, humongous change recently. But if you think about it, in America, our education system, everybody's got their own textbook. It depends on school districts and states and everything else. In Japan, it's one textbook. Everybody learns to write Japanese the same. They learn the history the same. They learn the culture the same. So you're talking about a very homogeneous bunch of people. There are distinctions. I mean, you're kind of Osaka people tend to be more merchants. Nagoya tend to be more tight. And there are different kind of stereotypes about things. But fundamentally, Japanese people all kind of start off the same. So they're thinking, I swear sometimes they all know what they're going to say in response to a point raised before, without saying anything. Everyone's their brain is almost wired together. So it's a different type of negotiation because the Japanese people really do come from a very common background.
Can I ask a quick question about China? In my experience with China negotiations, there's constant drafting of MOUs, and you have another meeting, and then there's another MOU after that. And I've seen that over and over again, and I was wondering if you have any comments about that, and if our companies from Hawaii are working in China, will they see the same sort of activity?
Yeah, so an MOU is a memorandum of understanding. I'm a little fuzzy on Chinese law whether or not it's enforceable. Under U.S. law, it's not enforceable. It's just hey, let's just have a little draft of things that we've kind of agreed on so we can move forward in our negotiations. I don't have a direct experience, but my best guess would be the Chinese side is eager to get you to pin yourself down because they're not pinned down. So they want to get you pinned down. And then, by the way, they're going to come back tomorrow and say, oh, yeah, by the way, Article 4 of that MOU, we want to change that to something else. And the closer you get to finalizing the deal, the more likely they're going to ask for changes because you're committed to the deal. You want this deal to close. You got an airplane in 4 hours you got to get on, so you got to get out of there. You're motivated to close it at what the cost. And they're just sitting there waiting for you to cave in.
Another quick question is on free trade agreements. If there are free trade agreements between the United States and another country, does that help contracting with organizations in that country, or is there no benefit whatsoever?
Sorry, I don't know.
We're not trade lawyers. Free trade agreements, bits, mits, and all these kinds of different things, they can help because they often have dispute resolution mechanisms in them. So one of the parts of the Trans-Pacific Partnership, why a lot of people were excited about that possibility, no longer a possibility for us, but for the rest of the region, because it had some very good mechanisms in there that the governments agreed to as to how to resolve commercial disputes. So they can be incredibly helpful.
Another quick question on translations. You mentioned several times if contracts should be translated into both languages. Who actually does the translations? Is it the law firm or is it a professional translator? And how do you determine that this translation is a good translation versus not a translation, or using translate.google.com, right?
Learn the other language up to the level of a native speaker is the only way you can reach a total level of trust. So there are translation services and stuff like that. It's complicated. At some point in time, you just have to sort of take a leap of faith. And if you don't speak the language, and the person with you is not all that sophisticated. One of my jobs at the Chinese law firm was to compare contracts and review memos and stuff like that. And so we did all of our translation in-house, typically by an associate. And the level of translation varied from associate to associate.
At Nagashima Ono, the firm that I worked at, very, very international firm, they had a translation department of, I would say, about 30 or 40 in-house translators. And then in addition, it was considered good training for associates to do the translations as well. We did use outside translators. A lot of times in New York, there's some really good ones. But yeah, it was a mix, and it depended on the client's budget and everything else. I guess one comment about translations, and I think Larry and I are clearly on the same page on this point. You'll never get a perfect translation. Every word that's used has a different nuance. In a legal system. For example, the American lawyers, we frown anytime somebody wants to put the burden of best efforts on our client, because best efforts really gets down to, like, you've got to almost, in some court cases, almost go bankrupt trying before you have met the level of that's required of best efforts. So you'll see your lawyers doing things like saying commercially best efforts, or in good faith, or reasonable efforts. They'll do everything but best efforts. But if you took the words zenryoku shite doryoku suru, or something like that, it doesn't mean the same thing. No matter how much you say it in Japanese as a direct translation, it's not going to translate. And every word there, so you go crazy if you try to create a perfect translation. So you try to get it as good as you can.
And particularly in legal translation, you want to have a translator who is law trained, ideally in both legal systems. A lot of people just bring in, and we have some highly skilled translators here in Hawaii, but they're not law trained, and they won't understand the nuance of a legal term or other kind of specialty terms within any kind of industry, and those are very dangerous translators. Yes?
Yeah, I have a question for Keith. I heard that the U.S. has about 5% of the world population and about 94% of all the lawsuits that take place throughout the world. And so my question to you is, in the U.S., we can say we have X amount of lawyers per X amount of thousands or hundreds of thousands of people. Do you know what that is in Japan?
Well, okay, in about 2005 or so, Japan made a huge effort to increase the number of lawyers. In fact, it was a trade negotiation item that the shortage of lawyers in Japan was impeding and was an unfair business practice by the U.S. trade guy. And so they started, their target was to approach the level of France insofar as the number of lawyers. And I don't remember the exact percentage, but I think the target was something like 50,000 lawyers by, I don't know, probably somewhere around 5 years from now or something like that. I would guess that Japan is probably something about, it's maybe 1/10 that of the United States. It's very small, but you know, one other thing you have to remember, the systems are completely different. So in Japan, you have bengoshi, you have bendishi, you have gyosei shoshi, you have shiho shoshi. So you have all these different types of guys that do sort of girls that do lawyer type of work. So the bendishi are sort of like patent kind of people. The gyosei shoshi are sort of like my partner's immigration lawyer. They do a lot of immigration stuff. So you know, you have different types of professions as well. And then the U.S. kind of just allows lawyers to do everything. So,
Yeah, if you just count licensed lawyers, it's an apples and oranges thing, and it doesn't work. Japan, like most of the world other than the U.S., offers law at the undergraduate level. So a lot of people get an undergraduate degree in law in Japan. Many of them choose not to become a licensed lawyer because it's a terrible process to become one, but rather they go work for a company, and they don't need a law license to work in a company. In the U.S., you have to have a law license to be a corporate lawyer. So it's a apples and oranges kind of a question.
I'll ask one last question, and then it's a segue into the distribution contract. Okay. Most of our small companies in Hawaii, or maybe not even small companies, but let's just say most of our companies in Hawaii, when they're starting to do business in a foreign market, and let's just pick China or Japan, they will be given the option of using the distributor's contract. Sometimes a small distributor might say, give us your contract. How does a company here decide which is the best path to follow? Is there a recipe generally that you two could recommend as to what a small company should do?
I smile only because as lawyers, and we don't mean this to get fees, but if you've got a choice, take control of the drafting. The person who puts out the first draft has the edge.
It comes back to market power, as you suggested. If you're a small company, I'm selling a widget that I make, and I'm just going to Japan, and I don't have any name recognition or market power, and I go to a distributor in Japan, probably that distributor has the market power and will tell me what they want, right? But how negotiable is that? I think that's where a lot of our small companies don't understand what their ability is in that relationship.
Yeah. Again, it's going to, well, the first phrase we teach law students is, it depends. So it depends on the company. This distributor in Japan, if they are a major distribution company, they have all the power, and it's take it or leave it. But maybe there's someone there in that office. They got to go through the levels of approval, but maybe they're willing to, make some changes that make the contract a little bit more tolerable to you. But particularly in Japan, because then they got to get all the approvals up and down the ladder. So that's going to be a complicated thing to do.
Is it your experience that most of those contracts that would be handed to a Hawaii company, would those be in English already, or are they in Japanese, and then you have to deal with that?
I hate to say it depends. But yeah, a lot of major Japanese companies do already have their form English contract. So, but the smaller ones, sometimes they will just hand you a Japanese one.
Okay, anything from neighbor islands, or are we okay? No? Okay, yes.
One quick question. So when we go look for an attorney to help us draft new contracts, what kind of attorney should we be looking for, like a classification of? So just like international capability?
Handsome, experienced. Yeah, you gotta shop around a little bit. And again, ideally you want a bilingual lawyer, and that limits it dramatically in any jurisdiction. Finding someone who has those bilingual skills. Ideally, also someone who's done distribution agreements before. Keith and I were talking. He and I have done. Well, I can actually in my career I've done 2 distribution agreements in 30 years. Maybe Keith has done.
Maybe
30, yeah. So here's an experienced pro. So again, you want a representation from your lawyer. Oh yes, I know how to handle. I do distribution agreements. I am bilingual. So you got to have a conversation with them.
one qualification. Distribution agreements is a very broad topic. So depending on the industry, it could be tremendously different.
Yes.
Is it possible that the Hawaii Bar list, when you have all the attorneys, do they list their expertise? I mean, because I think what people would be looking for is a resource that would list this person's bilingual, they work with these countries, this sort of thing. I know through HPEC, we're putting together a lot of resources for small to medium-sized exporters or anybody wishing to export, who they might want to go to for various resources. But I don't think part of that resource guide lists lawyers. I'm not sure about that, but we can check on that. But I think that goes to the question, because if you're sitting here and you're listing, and I'm thinking, okay, I need a bilingual lawyer who's going to handle Japanese or Chinese. I need to understand this. Where do I go? Who do I call? Where can I find that? So that's why I don't know what the bar lists when it just lists all the attorneys who are part of the bar, what sorts of expertise. Or does the bar have a listing of lawyers that are bilingual that actually work cross-culturally?
Yeah. So the question is, again, so sort of follow-up question: How do you even begin to know who to call, and find these kind of resources? So the Hawaii State Bar Association does have what we call a lawyer referral service. I suspect it's not as sophisticated as I need a bilingual lawyer. Japanese English to do a distribution agreement. It won't be that narrow, but it's like doing a Google search. You got to figure out your search terms, if you will. So maybe a lawyer experienced in international business who is bilingual, and they may have. I haven't looked at that database for a while, so it might be good. Yeah.
Yeah. So through the discussion, through what everybody commented, so wouldn't that ideal lawyer or company be one that has an office here in Hawaii as well as a sister office in Japan? And then that way they can talk and they can collaborate and they can have strong communication.
Yeah.
In a region to use.
Yeah. So the question is, isn't the ideal law firm is a true international law firm that has offices in country where you're looking at going to? And the answer is, yeah, wouldn't that be nice? I'm not aware of any Hawaii office that has in country. Oh, I'm sorry. Yes. So we do have one law firm now that has joined a international law group, the largest law firm in the world, and they have offices all around the world in all these countries, because you need that local lawyer a local lawyer on both sides, if you will.
But international attorneys here, even if they don't have their own company, say in Tokyo, they will have a predefined partner or set of partners that they will call.
Yes, yes. So Keith's firm is active in one of these sort of lawyer groups, international lawyer groups. So if Keith has an issue in Switzerland, he can look at his list within that group and call someone there. A lot of the major Hawaii law firms have that kind of loose relationship around the world. Yes.
And in a sense, you're gonna do like, sorry, it depends, but when you're looking at a small business to export, you need to have a custom contract. Are you looking at like setting aside $5,000, $10,000, or $100,000? Or it's like how much effort I guess it would take for you all?
Here comes it depends.
Okay, I want to thank the audience for yet another It Depends question. The one we've been dreading to come. How much is it going to cost? How much does it cost to do this? It depends. If you're just reviewing a contract, but again, the level of the cost rises with the level of skill required. So you're going to want so the ideal lawyer that you want to find is the bilingual lawyer who's done distribution contracts in that country before. And as you move up that expertise skills, you move up the attorney's fees scale. The good news is that Hawaii attorney's fees are about half of what they are on the mainland, or a third. There are lawyers in the mainland who some years ago crossed the $1,000 an hour threshold. In Hawaii, most lawyers, I don't know, $300 to $600 an hour, depending on their firm. And then how long would it take to do something? A 27-page. Well, they're not as fast as a computer, as it turns out. Although computers use a lot of electricity, maybe.
How about internationally, though? If you have to pick up the phone and call your loosely arranged group of colleagues in Tokyo, for example, I would imagine the Tokyo legal fees are pretty expensive.
Yeah, so legal fees vary around the country. This topic sort of came up with the intellectual property lawyers as well. And it really is, I hate to keep falling back to it depends, but it depends on the complexity of the task required by the lawyer. Yeah. Yeah. So the question is, for personal injury lawyers, you see in all their advertisements, if we don't win, you don't pay us. No, business lawyers typically don't do that. It's very unusual for a business lawyer to do that. You're going to pay an hourly rate. Having said that, get a list of lawyers to talk to. Go talk to them. They should be able to give you a ballpark figure. They won't commit to it 100%, but they should be able to give you some sense of what is this going to cost me before you and they go down the road of, a month later you get a bill for $20,000 and you say, what? So they should be able to give you some sense of what this might cost you. But again, pay the money up front. Don't hire. Do hire Keith's firm. They're an excellent firm, but you're going to pay 100 times more in lawyers' fees to fix a problem than to have done it right at the beginning. Yes.
I had a contract that came to me when I was in Shanghai, but it was actually delivered by more of an international firm. They delivered it in English. My cursory reading of it was I didn't care for the contract, so I called back to Honolulu, talked to an attorney here, also talked to them, where the organization was a nonprofit organization, but all business focused, and how much would they pay to review it, go through it, and negotiate it, and come back to us? because I knew I couldn't accept the one that was in front of me, and I needed one that was more favorable to the organization I was representing at the time. And the firm was very good, but again, it was one of the major firms here, the larger firms here in Honolulu. And the individual knew a lot about the topic and had worked internationally before. And I think the firm charged me around $3,500 or more. It was around $3,500, but I provided them what was given to me and said, what do you think? And they came back with a completely re-edited version. And with working with that firm, and I had something to negotiate with the people in Shanghai, and so we could go back and forth. To the end, it was, they didn't do the contract I wanted, I wasn't gonna sign the agreement, but because the dollar amount was so important to the other organization, they were willing to take the revised contract, which was head and shoulders above theirs, legally and the rest. So I had talked to other firms also, that major U.S. firms from other places in the U.S. that were represented in Shanghai, but they didn't have the expertise I wanted. And it wasn't so much on cost because they all kind of understood it was what they're working for, because some of them were templates, some weren't, but I was negotiating the substance of the contract. The templates are pretty much generally the same, but it was that substance that was just totally unacceptable. So I think, and that might have been an unusual because I knew the individuals in Hawaii compared to the others, but I don't know, and I agree, it depends on the sophistication, how much you want to do, if it's a basic contract or not. But I think I got something for around $3,500. I don't think it went up to $5,000. But the revenue stream off of that was in the hundreds of thousands. So for me, it was, you do it or don't, you know.
Yeah. So it becomes a business decision. That this friend that I co-teach with at UH Small Business Contract Drafting, he had a client. He was a small Hawaii solo contractor guy. He got a sub contract to perform worth $300 for this mega project. So the mega project sent him the standard contract. It was 300 pages long. So he takes it to my friend and says, gee, how much is it going to cost to review this 300-page contract and give me legal advice? And my friend said, hey, it's only $300. Just sign the contract and go forward. Well, that was a combined legal and business advice. That's wrong. He just gave legal advice. It's going to cost you a lot of money. And the guy made a business decision. No, it's just for a $300 contract. I could use the $300 right now. I need the cash flow. I'll sign it and cross my fingers.
Here's an online question from a neighbor island. I have a manufacturing agreement and a distribution agreement with an American arm of a Chinese company that needs review. Also heading to China to meet with e-commerce importers, including Alibaba. Will eventually have same contracts in China. Do you have anybody here locally you could recommend to this person?
So I don't know if the whole audience heard that. So this is some neighbor island who's looking at a manufacturing contract and a distribution contract, maybe multiple contracts out in China, and needs some. Who should they contact? So again, maybe start with the Hawaii State Bar Association. Get their international business lawyer. Or this local law firm that has become an international law firm, Denton's, may well have someone there.
Is it important in China to say you're doing business in Shanghai? Should you have a lawyer who speaks Shanghainese, or is Mandarin the law in purely discussed in Mandarin, or how would that work?
Yeah, so this is a Chinese language question, if you will. China's a big country, as we've all talked about already. Various dialects spoken around China. Certainly for big business deals, Mandarin would be fine. The law firm I worked at it started off as a sort of a Shanghai-based law firm. Almost all the lawyers were Shanghainese. The first language in the law firm was Shanghainese that I didn't speak a word of. The second language was Mandarin, and then following way behind that, Korean, English. whatever. But the primary language within a big city like even Shanghai with its dialect or Beijing would be Mandarin Chinese. You want to, and we know this well in Hawaii, when you leave the comfort of your little office, you want to appear to be part of the culture that you're going into. So if I'm from Kailua, so when I come townside, I try to pretend I'm from townside. So I wear shoes and long pants and all this stuff. So I don't want to be seen as some haole from Kailua. And the same. So if you're going to wind up in China going out to Chengdu or elsewhere, you want to be nice to have a lawyer from that area who spoke the dialect in that area. Once the Chinese language legal discussion starts, it's probably a lot of it's going to be in Mandarin. But again, you want to have the appearance of being one of them and not an outsider. In Hawaii, we have the phrase, "You're not from here." In China, the phrase is "YD run," which is someone who's not from here. Anyway.
We better jump into
Yeah.
the
Okay, so we're going to, I think you all have a copy of the distribution agreement. And you want to just start scrolling down for me? Go down several pages. So a little bit of background while he's scrolling. There's an organization out of Geneva, the International Trade Council, and they came up with some model international trade agreements. And they have agency and supply and services and stuff like that. But here's a distribution agreement. And they have a little bit of background that they'll talk with you about why they are important. And the importance of territory is very important in a distribution agreement to spell that out. But if you could keep scrolling down to the next highlighted area. So this is the contract itself. So it begins with the parties, and we've already seen this. So this is like the preamble, the introduction. So the name of the company, the legal form of it, country of incorporation, trade registration number. In China, every company has a number associated, a federal number, if you will, assigned to it. If that federal number does not appear on the contract, the Chinese courts will not recognize that contract. So if they say, "Oh, we don't have a trade registration number," they're lying. If they're in a business incorporated in China, they have a registration number, federal registration number, and you want to have that in the contract. We don't have that in the United States. They suggest putting address here. I think that's a bad idea. The address should be in the section of the contract talking about notices. Where do notices go? Because what you can wind up with is an address here and then a totally different address in the notice section. And somebody's going to make the mistake of sending the notice here when the contract clearly said send the notice to the address provided in the notice section. So just have the address in one place, and this is not a good place to do it. And also, the Puerto Rican contract did this. They gave the name and position and legal title of the person representing in the contract. I wouldn't put that in there. I put that at the in the signature page. This overall is it's a good contract. There's I didn't see really any 10th century English in it, so I was very happy with it. They did make, in my sense, overall, a couple of mistakes. They have a lot of passive voice in it. The money shall be paid. Okay, yeah, shall be paid. But who's going to pay the money? When are they going to pay it? To whom are they going to pay it? So they try to avoid the passive voice. Identify who the actor is. Who is going to make the payment is incredibly important. They also, you can skip up to the next thing. They also use the word, well, here's the background section. We talked about that. So supplier wishes to appoint the distributor as their distributor in the territory specified, so this is sort of fill in the blank, specified territory. On the one hand, that's okay, but if this is the only part of the contract that talks about what the territory is, this is the wrong place to put what the territory is. That should be in the substantive part of the contract, because that's incredibly important in a distribution agreement. And these kinds of background stuff are often, again, just they're not legally enforceable. It's just, this is, what is this agreement all about? Oh, we're going to do a distribution, we're going to set out a territory. That's okay, but when you specify the territory, have a special section in the contract titled territory, and then spell out what that territory is. Appointment of distributor, you got to choose exclusive or non-exclusive. Bargaining power. So your distributor wants to be the exclusive distributor, and you want to have multiple distributors, so you got to negotiate that. Territory and exclusive, non-exclusive, in some countries, these are deemed to be antitrust issues. So you might be violating antitrust law in the country that you're doing this thing if you agree for them to be the exclusive distributor, or the territory is the entire China, whatever. So you gotta have local counsel that knows whether or not this is a antitrust issue in that country. So here the competition law means antitrust law. We call it antitrust law. A lot of places around the world call it competition law. Okay. So this is sort of this is an important part here. So these are good contracts because they, to the extent that they identify what kind of issues do you want to have in your contract. This is the what ifs, what abouts. So distributor shall not get goods from anybody else that might be competing with you. You want to have that there because the distributor may want to have multiple suppliers with similar products so that they can be flexible and free and footloose and whatever.
Well, actually, I'll interject. We do see this with companies from Hawaii who, let's say they're making, hand lotions or soaps or oils. They're selling it to a distributor in Japan who has multiple lines of that, not just from Hawaii, but from elsewhere in the US or around the world. And what happens is the Hawaii supplier becomes a very small fish in a very big pond in that portfolio of the distributor. And the distributor is going to typically give more work towards their bigger suppliers, or the squeakier wheel, if you will.
Yeah.
And so how can we ensure that our companies are building this into their contract?
Well, you'd start with something like this, or something like a clause like this, but then maybe sort of build upon it and get some language in there. And the more you as this mom and pop supplier in Hawaii want a major distributor in Japan to give you the same status as Revlon or L'Oreal, good luck on that. They're not gonna agree to that. So it's a bargaining power kind of a situation. Okay. You can keep on going. Supply of goods. So distribution agreement. Basically, what you're doing, you the supplier is selling your product to the distributor. So 50 cases, 100 cases of X, Y, and Z. They're buying it from you. We talked about the schedule in the contract. So the schedule in the contract will list all those particular goods. So there's no confusion as to what goods were agreed upon to be part of this distribution contract. So the distributor may have wanted to have a distribution contract with you because you have a product over here that they really want, but you, for whatever reason, only want to give them this product. That needs to be spelled out in the contract rather than just sort of a oral assumption or understanding or something like that.
Where would you go? You have an agreement with a company for a year or two and it's successful or reasonably successful, but then you develop a new product, and how do you add that to this contract through an addendum or?
Yeah, basically you'd negotiate an addendum to the schedule. Distribution contracts, you need to be flexible. They should be shorter, relatively short term, because prices change, product lines change. You as a supplier want to have, as the company, want to have some flexibility to make those kind of adjustments. If you lock yourself into a 10-year supply contract at a fixed price, you're dead meat, 5 years from now, because your costs have gone up, but you got to sell it to them at a 5-year-old cost. Okay, minimum purchase obligations. So you're selling Aloha shirts, and you're requiring them to buy 4,000 Aloha shirts a year. You don't want them to say, well, we'll buy them when we need them, because that messes up totally your manufacturing side. So you got to have a specific number in mind and put it into the contract, and then the procedure for ordering the goods, all of that. Okay. This is important, and I'm saying we're at 11 o'clock, so those of you who want to go home, feel free to go home. Yeah. There's still food in the back. I'm just seeing the food in the back anyway. So this is important. So distributors shall be responsible for obtaining import license and other requisite documents. So whose responsibility is it to get those approvals from the country to which you are going to be exporting your goods? Whose responsibility? Who's going to pay for it? That should be spelled out in the complying with all the applicable laws or regulations. One that comes up from time to time is we have some very fine hardwoods here in Hawaii. Japan has some pretty strict guidelines on importation of hardwood stuff. And there was a big organization here that was doing an event in Tokyo, and they were shipping ahead. I don't remember what the wood was. It was either koa wood or milo wood frames for these certificates of appreciation. And it got to Japanese customs and said, no, that's not on our list. We don't accept this particular wood. We don't accept in Japan. So you got to, again, sort of know what those local rules and regulations are. Keith talked about this earlier, these kinds of qualifiers, reasonable commercial endeavors or best efforts. These are hotly negotiated, because you, the supplier, want to protect yourself. The distributor wants to protect themselves. So who bears the risk? Again, is a question of bargaining power. Okay. And again, early on in the relationship, the bargaining power is not quite even, but there's more room. Later on, as things get set, the bargaining power goes down. And then we talk about price increases. So, supplier reserves the right to increase the price of goods. If there's been some unexpected material increase, manufacturing, whatever. And again, so delete if not appropriate. So that's negotiable. Do you have the right to charge more if your manufacturing costs go up? That's got to be in the contract. Don't try to negotiate it when the issue comes up. Yeah.
Do either of you guys have examples of retail price control in a distribution agreement to make sure the distributor or their customers aren't selling something unusually low?
Yeah, I believe that's in this contract. Don't ask me where. It's only 27 pages long. I find when I'm looking for something in a 27-page document, it takes me 5 times reading it to find what I'm looking for. But yes, that should be something that's in there. Okay, next.
I like that this calls out Ex Works or FOB. Those kind of legal terms are important to get into these.
Yeah. So as an exporter, you need to sort of memorize these terms. I have no clue what they mean, but they're important for exporters. Payment. You want to get paid. How does payment take place? So within 30 days or any other period, you got to submit an invoice. To whom do you submit the invoice? What address do you send the invoice? That information to me is sort of missing here, but you got to make that clear. What's the currency that you're paying in? Are you paying Chinese dollars, U.S. dollars? What about the changing, fluctuating exchange rates? All those things should be in here. Okay. Warranties. Okay, so warranties, representation. So here's some warranties here. I didn't see any representation, but they had warranties. So supplier has, or at the time of delivery will have, you can delete that if you wish, good title to all the goods supplied under this contract. So what that means is, does anybody have a lien on your goods? Are you delinquent in your loans to the bank and they put a lien on your warehouse? You don't have good title to those goods anymore. But you need to make a warranty to the distributor that you do. So this really helps the distributor that you actually own the goods, free and clear of any encumbrance to send to them. And then so this is sort of the workmanship, the quality of the product, comply with all health and safety regulations, other legal requirements. That's a warranty made by the supplier. So the supplier needs to know what the health and safety regulations are in Japan, China, Indonesia, whatever, as you send this product out, because your distributor is going to want you to warrant that you know what it is and you comply with those. Okay.
Where would labeling, like if you needed to label something in Japanese per law, where would you put that?
Probably in this section talking about the goods and stuff like that. Yeah, it'd be in this section. So distribution of goods. Distributor shall use its, again, reasonable commercial. So reasonable commercial endeavors is a nice middle ground. You don't have to really be that, judges around the world are comfortable with the word reasonable. There's a lot of ambiguity to it, but people are comfortable with it. But depending on bargaining power, it could be best efforts, and then that's what Keith is talking about. Even if you go bankrupt, who cares? You promised you would do everything possible to do this. Did I tell you it was a long contract? Okay. Proper books of account and records. I told you, don't trust anybody. Don't trust your distributor. You want them to have good books and records that you can review on a regular basis. I remember at a meeting in a casual event in China, people were talking about, the Chinese, they have 2 sets of books, and everybody laughed because they know they do. And then another CEO who'd been in Europe, he said, well, you got to go to Egypt. They have 8 sets of books in Egypt. Know your local culture and how many different sets of books there possibly are, and make sure that you are able to understand them. So you got to have an accounting from your distributor that you can follow. Okay. So distributor will do the marketing and promotion and after sales and maintenance at their expense and with due skill. So you want to have this kind of provision in there. The Korean agreement that we worked on in Shanghai got a little complicated because the Shanghai distributor wanted a provision in there that he's going to be paid up front for all the illegal bribes he has to pay to the supermarkets for product placement. We decided not to put that particular language phrased that way in the contract, but just agreed to add an extra X number of dollars for marketing purposes. to be sure. Product placement is all around the world. You go to Safeway. It's all about product placement. I like products that are at this level. My wife likes them down at this level. But product placement makes a huge difference in training. Support and training. Enough said on that. We can keep going. So the support and training sort of depends on the product. If you're selling a Aloha shirt, you don't need support and training. But if you're selling some kind of other more sophisticated thing that software, for example, then you need to provide training and software support for that. Okay. You can keep on scrolling down. So intellectual property. It's a long section because intellectual property, as we saw the other day, is important stuff. As they were saying the other day, I won't say it's common, but it's not unusual for a distributor to take your product, and this happens all around the world, take your product, give it to their friend at another factory, at a factory in that country, and they'll produce it at a third of the cost and sell it, and you've lost everything.
Just add this section ties in nicely to the seminar we had last week on trade marks.
Yeah, yeah,
It's very important stuff.
yeah, yeah. I talked about trademarks and all of these things. Confidentiality. So if you're selling Aloha shirts, maybe that's not a particularly important provision there. But other kinds of products or services or whatever may involve some kind of confidential business information. And this is the what ifs and what abouts thing that lawyers get involved in. So the lawyer needs to know what your business is to know whether or not there's a possibility of any kind of confidential business information that needs to be protected. Liability. Oh well, I probably shouldn't have highlighted this. This is if the distributor sends an employee to your company premises to better understand the product and stuff like that. What happens if the lawyer slips and falls? I mean, the employee slips and falls. What if the employee, that foreign employee, assaults one of your workers, or one of your workers assaults them? This is the what if stuff that American lawyers love to do, and try and address it up front. Duration and termination. So this is this contract will take effect on the date of its signature, and this contract shall continue for a period of X years, months or days, whatever. Let me comment briefly on the use of the word shall. Keith's laughing already. It turns out shall is one of the most ambiguous words in commercial transactions. The U.S. Supreme Court hates the word shall. They say the word shall means must, or it could mean may, or it could mean will. And how do you determine which one it is? So that's why in more modern contract drafting, we try and tell people only use shall if it's an obligation by one of the parties. And here they're saying where did I see where was I? No, that's an entitlement. Where did I see that? Shall continue for a period of. Is that will? Or is that you're just talking about time, or are you talking about a requirement? It must. So it becomes an ambiguous term here, and ambiguity is a bad thing. Sometimes you do ambiguity on purpose. That's okay, but if you do it accidentally, then it can be greatly detrimental to your client. Shakespeare loved it. Yeah, it's 10th century English. Get rid of it. Here and after, here and below. whatever. Chaucer was a master of it. 21st century lawyers should never use it. Consequences of termination. So again, we talked about this earlier on at the very beginning. So it's a 3-year contract. All right, so it terminates automatically after 3 years. That's not a problem. But what if there's a problem in year 2, month 2, whatever? How can we terminate this contract? That should be spelled out in great detail in the contract. Consequences and process. Okay. Change of circumstances. Things change all the time. So you want to write that into the contract, perhaps, depending who you are. Whose circumstances? So you don't want to give any change of circumstance out for the distributor, but you as supplier want to have all the outs possible. So you write that into the contract. So hardship. This sounds like sort of the fairness and equity thing that you see in Chinese law, Japanese law, Sharia law. That there is some fundamental fairness thing that we can look at. So in Japanese law, it's part of Japanese legal culture, Chinese legal culture, but here it's maybe nice to also bring it into the law, make it legalistic if there's a hardship issue. Okay. Force majeure. I don't even know, is that French or I'm confused where the term came from exactly. Lawyers usually love Latin, but here it sounds more like a French word. So something big happens. So Hawaii, occasionally we get hurricanes. What if your factory is obliterated by a Category 5, and yet you're obligated to ship out goods to your distributor? Can you get out of the contract? Well, the good news, yeah, you got a force majeure clause here that is going to protect you. The language of it is pretty important, and you should find a good one and use that. Read it carefully. Read the force majeure clause carefully. The Chinese love to use force majeure clauses, and buried inside a very long clause would be a little provision. Oh, by the way, if we can't get our money out of China, we don't have to pay you, but we get to keep your goods. How cool is that? Okay, so read these clauses very, very carefully. General warranties. So these are these warranties back and forth. This is the merger clause. Entire agreement. Keith and I, we got to know each other. We had a lot of fun, and we're good buddies now. And he made all these assurances to me that that don't worry about that, don't worry about this. Oh, that's not what it means. I had to write that down because my boss wanted it, but don't worry about it. No, have a merger clause in there. If it's not written down in the contract, it doesn't exist, and it's not enforceable. Apparently some exceptions in Japan again for the fairness thing. Notices and writing. This is where you put the address. And ideally, you only want to put it in one part of your contract because it's so easy. If you have address in multiple parts of the contract and an address gets changed or you make a typo or whatever, suddenly you got 2, 3, 4 different addresses in the contract. Which one do you use? Only have it in one place, and ideally in this here. So address for the supplier, for the distributor. No partnership or agency. What is the relationship between the company and the distributor? Are you just good friends, or is it a distribution agreement, or is this some sort of a partnership, or is it an agency agreement? Yeah, I know the top said distribution agreement, but when you read the document, it looks like it might be an agency agreement. The way it's all, everything is structured. Have a particular clause in here. This is not a partnership. This is not an agency agreement. Can we come down for just a second? Shall, one of my least favorite words, but be deemed. Passive voice. who makes this determination? Is this a determination by a court of law, or did your sister tell you that it looks like it's this? Passive voice is very dangerous in a contract. Assignment in subcontracting. So we looked at that assignment clause, and you can make it very favorable to one side, favorable to the other, or more even-handed kind of a thing. But you need to have this kind of a thing in there. Okay. You can keep scrolling down. Dispute resolution. Very, very important to discuss this in the contract and spell it out. I know in Honolulu, for example, there's a group of lawyers who say only use ADR. Litigation is far too expensive, and they advocate never resort to litigation. Use alternative dispute resolution. It's the only way to go. They're very firm in their beliefs. Standing next to them is the other group. Never use ADR. Always do a lawsuit, and they're very firm in their stance. So there's no good advice on this. I tend to prefer alternative dispute resolution, but understand there's sort of two groups out there, and they each have their point of view. Language of the contract. We talked about this. Keith and I talked a bit about this already. Which language is being used? Let me quick language anecdote. I got nothing else to do until 3 o'clock. A quick anecdote. Take you back to the 1930s. Japan annexed Korea, and the United States says, "Oh, what's happening over there? We don't understand what you guys are doing." And so the Japanese sent them all the documentation, and the U.S. State Department says, "Well, gosh, it's in Japanese. Would you mind so terribly translating this into English for us?" And the Japanese smile and says, "Of course we will." And the English version was a treaty of friendship and cooperation. No mention of the word annexation. So be very careful about the different language or language differences. Trust no one. Okay. Applicable law. So again, is it U.S. law, some kind of international law, Chinese law, Japanese law? That should go in the and you need to know the law of that other jurisdiction. Even the United States, under Hawaii law or New York law, there are some big differences for commercial disputes there. And if you don't know the law that you just agreed to, then you could be dead meat, because I guarantee you the other side does. Okay, so this is sort of schedules and things. There's one more thing near the end to look at. List of trademarks, signatures. So maybe that's it. Okay.
How are international agreements like this? Do you need a notary? I would see from Japan or some other countries there might be a hanko on there. Would a local supplier here need a hanko for something like that?
Yeah. So in China they don't call them hanko, but you got to seal it. You chop it. You got to have the chop. And then Korea, Japan, the same. You got to have a chop. So and that's very important, because in theory there's only one chop. In Chinese business disputes between partners, the first thing that disappears is the company chop, because without that chop they can't go banking, they can't make payroll or anything. So there's a lot of power behind that chop.
Depends on where you're going to try to enforce it. For example, if you have a Japanese company that is buying something in Hawaii, real estate, then a signature is fine, and it doesn't have to be notarized or anything. If you have the Japan situation, you may need to have a document, actually a stamp, a documentary stamp, to enforce that in court. It doesn't nullify the agreement in the meantime, but to get to court, you're going to have to, and you pay money, sometimes big money, for that stamp.
Yeah. So, notarization is going to, it'll sort of depend on the, it depends. Again, if you want to enforce it in China, or China needs to take it, the Chinese supplier needs to take it to the foreign exchange office there. That foreign exchange office, to get U.S. dollars, the foreign exchange office will require a notarized document, and actually several levels above a notarized document. In the United States, notaries are just law firm secretaries, and if you've ever purchased property or something, and the notary just said that person showed me their ID, and that person signed this document. In China and I assume in Japan too, notaries are a totally big profession. So the Chinese notary will, if it's a company, they will ask you for proof of who you are, proof that you have the authority from the company to sign this contract, and other kinds of proof. So they spend a lot of time and hence high cost to quote unquote notarize this document. Yes?
Yeah, at the very early stages of discussions and you working with an interested party that may be a distributor, at that point in time, is there any other tools that you could use that would be a lot more ironclad or stronger and binding than an NDA? Because again, when you're working internationally and you're signing an NDA, how strong is that? And how can you pursue if there's a breach or a infringement on it? So is there any other tool that can be utilized at that early stages?
Yes, consult your lawyer. And it'll be country specific. Some countries are happy enough to enforce NDAs, some countries are not.
Can you just review what is an NDA?
Oh, non-disclosure agreement. So particularly if there's sort of like a process behind your whatever it is that you're selling. Again, if it's an Aloha shirt, you don't need a non-disclosure. There's no trade secrets involved. NDA, non-disclosure agreement, typically goes to if there's some sort of a trade secret or particular intellectual property component to it. But they always do one, but consult with someone who knows the country that you're dealing with to know whether or not that's enforceable.
I can tell you that one thing that some people try to do is to have a representative appointed and authorized in Hawaii to receive service. In the event you get into a lawsuit on an NDA or any type of agreement, then you don't have to go to Japan to try to enforce that agreement. You can serve the person here in Hawaii instead, which is always one of the biggest hurdles trying to tell you the truth, I don't know if that works or not, because there is the Hague Convention, which basically sets forth a procedure for you to serve somebody who's not living in this state. And so it might come down to personal jurisdiction versus, in rem jurisdiction and those types of things. It's a complicated area, but some people do try to at least get that so you don't have to bypass. You can try to make the argument that this person has been duly served and I'm going to sue you in Hawaii, and it's going to cost you a lot of money to fight everything in Hawaii.
And the non-disclosure agreements and these kinds of things and confidentiality agreements are not favored by the courts, U.S. and foreign, because they're seen as a restraint on trade. So they're very careful to look at them. So if it says you can't do X for the rest of your life, it will not be enforced. If you can't do X throughout the entire world, it will not be enforced. So you need to check with a lawyer and make sure that it's again, it comes back to sort of the reasonableness and fairness of the restriction on the other party. Okay, it's a wrap. All right. No questions. No questions. I'm getting hungry. All right. Thank you, folks, very much for your patience, and good luck to you. And if you need any help, call Keith.
Thank you, everyone. Let's just make sure there's no online questions real quick. There was a question about what were these articles here, 21 and 22, because I scrolled through them kind of quickly, and then the schedules here. But the online audience has a copy of these. I put them in a Google Drive so that they could download them, and they're watching them at the same time. So with that, there's no online questions, so we'll close this seminar. Thank you, everybody, for coming, and we will see you soon. May, we'll have a trade show seminar, and in June, we have a logistics seminar, so we'll see you at that. Thank you very much. Mahalo. Thank you, guys.